Good morning, everyone. Kind of wave at me if you can hear me. Everybody hear me? All right. So welcome to our 7th seminar, a Zoom seminar on legal topics. If you want to send me an email, I can send you a link to the 6 previous ones. And after today, we'll be able to send you a copy of this one if you'd like to see it again or share it with someone. I'd like to introduce Hunter Chamberlin, who's our co-host today on this seminar. And Hunter, I can't hear you though. Can you? Oh, you're on.
There we go. That might help. How's that?
That's great. Sounding good. You dressed up for the occasion.
Well, you know, I have to look like a lawyer, right?
All right. Well, I wore a tie, so maybe I'm close. So Hunter is a practicing attorney. He's been a guest on the radio show Ask an Attorney all about Florida law many times. Hunter has a varied practice areas. He's former state attorney. We usually, when I have Hunter on, we're talking about concealed weapons, or we're talking about criminal law. We're talking about stand your ground cases. We're talking about sealing, expunging your record if possible. So we have a lot of topics like that. But and today we're kind of limit the seminar to concealed weapons and gun law and stand your ground and sealing your records, and talk a little bit about planning if guns are in your estate, how to plan for those. So Hunter and I had a little talk this morning and decided to take your questions from the chat room as they appear. So if you already have a question for us, anticipating that we might be able to answer it for you, you can just send me a question to the chat room now. And we'll let everyone hear the question, of course, and hear the answer. And if you have a question about concealed weapons or stand your ground or gun law in general, or about what to do with the guns in your state and so forth, just go ahead and post your question now. Hunter, why don't we start the program with you telling us a little bit about some recent stand your ground cases you've handled.
Well, one of the most notable changes occurred about a year ago, prior to a decision by the Second District Court of Appeal. And without getting too in the weeds, the 5th District disagreed with the 2nd, and ultimately the Florida Supreme Court decided in favor of the 2nd District, which is the appeals court that we're under here in Tampa. Prior to that decision, stand your ground, the burden was on the defendant to prove by a preponderance of evidence that he or she was entitled to the immunity. For those who are not familiar, although I think everybody's probably heard the term stand your ground, let me briefly explain what the stand your ground law is. The stand your ground law is a statute that makes a person generally immune from criminal and civil actions, criminal prosecution and civil action, when that person justifiably uses or even threatens to use force under certain circumstances. And there's less than deadly force up to deadly force. So when we talk about stand your ground, what we're talking about is a legal use of force in defense of oneself or someone else. And the biggest change, as I said, was about a year ago. If, for example, I had been charged with a firearm offense, aggravated assault with a firearm, and I wanted to articulate or espouse a stand your ground defense, which is different than self-defense, and a self-defense argument in trial. The stand your ground is a preliminary defense. Before the prosecution even begins, I stand up and say, I'm immune under stand your ground. The burden was on me to prove to the court that I was entitled to the immunity. Well, the courts, the 2nd District and the Florida Supreme Court changed that and said, no, a person is immune when they make the argument that they are immune, and it's up to the state to prove that they are not entitled to the immunity. So it shifted the burden essentially from the defendant to the state. The state has to now prove that you're not entitled to it versus the defendant proving that you are. So that's one of the biggest changes, and probably the most significant changes in the stand your ground law recently.
I don't know. Let's talk about the recent case. I think it was in Texas where a couple, I'm not sure it was Texas, but they were standing, I'm not sure everybody's familiar with this. They were standing on their porch. I think the husband was holding a rifle. I'm not sure what the wife was holding. There were protesters marching down their street. It had done damage to some houses prior to walking in front of their house. And they were arrested and charged with, I'm not sure what they were charged with, but they were arrested probably for showing a firearm on their front porch as a weapon. So how does that all relate to the stand your ground and concealed weapons and gun law in general?
Well, assume for purposes of today that occurred in Florida. Obviously, Texas law is different than Florida law in a number of respects. But interestingly, that wouldn't necessarily come under the stand your ground law. And let me explain why. The stand your ground law came out of something that was called the Castle Doctrine. Everybody may have heard the term, a man's home is his castle. Well, prior to the passing of the stand your ground law, the Castle Doctrine, which goes back to English common law, the Castle Doctrine said that in your house, you have no duty to retreat in your house, in your own home. So even if somebody is attacking you and there were a way you could retreat, you're under no obligation to do so. You may meet deadly force with deadly force. The stand your ground law simply took that Castle Doctrine and took it outside of the home. So now you essentially have the Castle Doctrine wherever you go, with exceptions, of course. But the reason why it wouldn't necessarily come under the Castle Doctrine is because Florida has a separate and distinct statute, 776.013 for those that are interested, that is titled the Home Protection, Use or Threatened Use of Deadly Force, Presumption of Fear or Death or Great Bodily Harm. All of that, what that statute says is that if you are in your own home and you reasonably believe that your house is being broken into or you are facing deadly force, you can meet deadly force with deadly force. And there was a famous example in Florida, maybe not so famous, but analogous to that case, the Texas case with the folks standing on their porch. Very briefly, the facts of the case were that a gentleman was living in a house with his daughter. The daughter answered the door late at night. Somebody grabbed the daughter, dragged her, two men dragged her out of the house and tried to abduct her. She called her father. Father came down. The people ran off, and the father was standing on his outside covered porch, just as sort of the outside his house, but still within his property, and began firing at the people that were trying to take his daughter. They fired back. Everybody was shot. Everybody lived. And the court ruled, of course, now that is justifiable. He had a reasonable fear that his daughter was being abducted, and therefore it was reasonable for him to use deadly force. So the question that everybody asks is, why was that case even prosecuted? It's so clearly he had the right to do what he did. As Paul Harvey said, the rest of the story was that the people breaking into the house, or not breaking, but trying to abduct the daughter, were actually police officers trying to serve an arrest warrant. Of course, the gentleman protecting his daughter didn't know that. So in that case, the court ruled that that was a justifiable use of deadly force.
All right, Hunter, so we have a couple of questions from the chat room. Somebody corrected me and said they weren't from Texas, they were from St. Louis, so thank you.
That's correct, yes, St. Louis.
All right. So question is, a person wants to know, it says, I'm a veteran who has worked in the security police, USAF, taken many weapons training classes with many different kinds of weapons. Can I take a concealed carry test online without going to a range for certification, is his question.
I believe the short answer is no. Having gone through this myself, the concealed carry class involves both a written test and a practical component to it. I recall having to go to the range myself and it was not, you didn't need to be an expert marksman. You just needed to basically show gun safety, that you knew about gun safety, and that you could generally aim the gun down field and hit a paper target. But so I'm not aware of an exception to that. I believe that to get a concealed weapon permit,
My wife and I took the class and everything and went to Shoot Straight, I think, in their classroom and did everything. And there was a police officer who part-time taught these classes and everything. And I'm sure for our person who sent the question in, they could arrange for to do this privately. I mean, a certified teacher who teaches these courses, who's probably going to be a police officer or a retired military person who's taken the classes to teach the class, could meet with you privately to do the shooting part of it, I would think.
Sure.
I think that could be arranged.
Yeah, I believe that's true.
Another question from the chat room. If you have a question, just send it to us on the chat room. We're going to talk with the session lasts an hour. We're going to talk about a various number of topics, and we're going to take your questions from the chat room as they come up if we can. Question is, what is a proper way to conceal carry in a restaurant or a bar or a lounge?
Well, those are different questions. The law does not allow you to carry a concealed weapon in a bar, defined as an establishment that makes more than 50% of its revenue on alcoholic beverages. So you with a concealed weapon, you'd be permitted to go to a restaurant like Outback or something. So there are rules about that. I'm trying to see the question. I'm not sure I saw it, so I'm trying to remember the rest of it.
Well, it just says, what's a proper way to carry a concealed weapon into a restaurant and or a bar?
Well, so if obviously it has to be concealed in a holster, either under a shirt or somehow not visible to the public. There is no open carry in Florida, with a number of exceptions, but we don't need to get into the exceptions. But generally speaking, there's no open carry in Florida. So if you are going into a restaurant, then it just has to be on your person and concealed from ordinary sight. Now, where that comes into play, and there are a number of cases that I've read and in fact even been involved in, where the police get called because someone calls 911 and says, I saw somebody with a firearm concealed on their person, and the police will show up and they'll detain the person. That is an issue, because just because somebody has a firearm does not mean that they are necessarily breaking the law, because I think I read that if you add concealed weapons permits and you add security officers licensed to carry and a whole number of other people, it's 1 in 7 Florida citizens are permitted to carry a firearm. So it's not reasonable suspicion that a crime is about to occur or is occurring simply because somebody has a firearm on their person. The police need more. And when we encounter, as practitioners, as defense counsel, encounter a situation like that, our first move is to look to see if there's a suppression issue and have the case ultimately be dismissed on those grounds. The other thing that comes up in those contexts is the brief inadvertent disclosure. And there is so if it's on your waist, for example, and you reach up and somebody sees a butt of a gun in your waistband or in a holster, that is not, by statutory definition, that is not open carry. That is not unlawful display of a weapon. What makes it an unlawful display of a weapon is a purposeful display in a threatening or menacing manner. So even take that one step further. I actually had this case. My client was going into, I think it was a Walmart, whatever, it doesn't matter. And in the parking lot of the Walmart, he took his handgun out and put it into his private vehicle. And somebody saw that and called the police. Police show up. And ultimately, that case was dismissed because that was not open carry. He didn't display it in a threatening or menacing manner. So the police came, and I think this was in Polk County, where obviously there's a lot of people who value the Second Amendment. Police basically showed up and said, "Yeah, there's nothing here." So
I have a question, Hunter. So I don't know why I thought of this. I just thought of this. So what if a person had a holster with a gun inside of it, but you couldn't really see the gun, you just saw the holster? Is that would that be considered open carry? If you could, if I put a holster on my belt and just was carrying a gun around inside the holster, but you couldn't see the gun, you just saw the holster, is that a concealed weapon?
no, I would, that would probably would fall under an open carry. If you have an open holster that appears to be not empty, shall we say, then that would qualify as open carry.
Well, what if you had a holster that was empty, and you wanted to appear that you had a gun? And don't mess with me, I've got a gun. I mean, you wouldn't say that, but you want to carry that holster around with you. Is that a crime?
Well, as you know, Joe, the law is not a black and white or binary proposition. As you start sliding towards different scenarios in that situation, I think it's a gray area, but I think that certainly law enforcement and the prosecutors would consider whether you had a gun or not. By intimating that you did, you are potentially threatening to use force or deadly force, and probably wouldn't end well for you. But the more practical consideration is one ought not to pretend like they have a gun and act as if they do and say they do when in fact they don't. There are, aside from legal implications, certainly implications.
Yeah, Hunter, has that case been settled where the older retired police officer shot the guy who threw popcorn at him in the movie theater?
Has not. As far as I know, that case is still pending, and which years later is amazing to me.
All right, so here's a question for you from the chat room. It says, my dogs have been attacked by loose dogs 4 separate times while we were out for walks. I now carry a stick and dog pepper spray when we walk. Am I legally allowed to carry a cattle prod? And it says bear spray as protection against loose, vicious dogs. It probably sounds like a funny question, but trust me, it's not funny having a dog run up and start biting your dogs. Thanks.
Interesting. I handled a case very similar to that. The facts were a little bit different, but a neighborhood dog came onto my client's property and killed their dog. And they went to retrieve their dog, and the dog started attacking them. My client took out his lawfully carried firearm and eliminated the threat, shall we say. And the police came up, they investigated and said, no crime here. So a couple things. First of all, I assume that the person that posed that question has called animal control and reported this each and every time. If those dogs continue to be a threat, animal control will handle that situation. And if that dog is on the loose, animal control will come and contain that dog and take it to a shelter and issue a citation, and it will be dealt with. But that doesn't solve the more immediate problem of the potential for bodily injury or attack. And the short answer is yes. If you have a reasonable fear that that dog is going to cause you serious bodily injury or death, you have the right to protect yourself.
Now, what happens to a person who, like in this case, did not have a concealed weapons permit, was carrying a gun with them on the walk with their dogs, gets attacked by a dog, either their dog or themselves, pull out their gun and shoot the dog, and they didn't have a concealed weapon permit? What would happen to that person?
Well, that person in that situation could potentially be charged with carrying a concealed firearm, without a license.
And what's the penalty for that?
Well, it's a it is a, I believe it's a third-degree felony. So it depends on a number of factors. It depends on their prior criminal history. It depends on a number of things. And it also depends on the jurisdiction. I've handled similar cases like that in Orlando, in Hillsborough, in Pinellas, and each jurisdiction has a bit of a different emphasis on that. The case that I handled in Orlando that was somewhat similar to that, this individual was actually in the process of getting his concealed weapons permit, just hadn't had it yet. His girlfriend had a concealed weapons permit, had a firearm, couldn't fit her firearm into her purse, and so gave it to her boyfriend, who held it for her. And through unimportant facts, ultimately that was discovered by law enforcement, and they prosecuted him for carrying a concealed firearm. And I was trying to get him into a diversion program. I think in Hillsborough he would have been eligible for a diversion program, whereas in Orange County they take that a little bit, I don't want to say more seriously. They handle those more strictly, I think, than Hillsborough. So they would not allow him into a diversion program. And so he had to ultimately plead to it and was put on probation for a short period of time.
Yeah. All right, so another question. If you have a question that you'd like to Hunter and I to address in the chat room, just send us, if you're on Zoom, send us a chat room question here. Question says, if my memory serves me correctly, in 1970s, open carry was legal here in Florida. When did it become illegal?
I don't know the answer to that. I alluded, though, that there are exceptions even today to Florida's open carry prohibition. And among those exceptions are if you are camping, hunting, fishing, and there's a number of others. And so I have heard stories about people that will test that and test it only to reinforce the law enforcement that is permissible and legal. So, for example, I've heard stories about people that will go onto a fishing pier and begin fishing with a firearm visible on their waistband, and the police will, of course, be called. Police show up, and then these people are prepared. They have the statute. They hand the statute to them, and it's a way of reinforcing to the police that what they're doing is lawful. But those are some exceptions to the open carry prohibition. I'm not sure, frankly, when it changed.
You know, what's the rules on when you're hunting carrying weapons? Are there certain areas where you can hunt without a special permits or anything? If you're on a farm, for example, where people go to hunt deer, are there any special rules about guns in those circumstances?
Special rules about guns versus special rules about whether you can hunt. So those are two different questions. If you are on private property and you're not within the municipal boundaries of say Tampa, which you wouldn't be if you're on land that's big enough to hunt. If you're on private property and you have permission to be there and you have permission by the property owner to have firearms, I don't know that there's any prohibition on having firearms in that regard. I believe you would still need a permit to hunt through the FWC, Fish and Wildlife. But that's different than a scenario where, for example, you're on public land, government-owned land. Then, of course, different rules apply.
Are there any rules about if you're on a boat and you, let's say you shoot, I know there are bow and arrow type of things where you can shoot or kill fish with like a bow and arrow type of weapon, we'll call it. Any rules about that?
Well, there are different rules for firearms than for bow and arrow. If you have a firearm and you're within, offhand, I don't recall the exact number of miles. I think it's 3 miles. It might be 5 miles.
3 miles sounds familiar.
3 miles. I think it's 3 miles. You're generally prohibited from shooting firearms within 3 miles, even if you're on the water. within 3 miles of land. The other thing that's interesting about that too, Joe, is, and this is somewhat related to firearms, but obviously we all know about Fourth Amendment search and seizure. You have a right against unlawful searches unless there's a warrant. Fourth Amendment common prudence, jurisprudence. On the water, even if you are in the middle of downtown Tampa, on the water, there is no Fourth Amendment right. The police can search your boat anytime without any degree of reasonable suspicion whatsoever. And you see them doing that. They will just randomly stop boats and say, you, pull over. I want to see if you have the right number of life jackets. That is totally permissible. And it comes under an exception to the Fourth Amendment. It's the similar exception to, you don't have a Fourth Amendment right at an airport. You don't have a Fourth Amendment right at a port. And it's because it's has to do with entry and into the ability to enter the country. That's why you don't have a Fourth Amendment. So point is, if you have a firearm on a boat, just be prepared that the police can search your boat at any time.
On another question from the chat room, it says, have you had any experience with any of these companies that provide insurance to those involved in a shooting? And I'm thinking that probably means they cover, if you have a concealed weapons permit and you shoot somebody, there's some type of insurance or program to help those shooters in that case.
I know those exist. I personally don't have that insurance. I'm not all that familiar. I know generally the concept is that there are companies through the NRA or through various shooting clubs where you pay an insurance premium, and then in the event that you have a firearm charge, they will either help or fully pay for defense counsel to represent you. They will provide insurance and civil liability realm. So I think it's like car insurance. There are different types, but that is something that exists. And it's probably not a bad idea for people to look into if they do have a concealed weapons permit or if they own a firearm at all.
So a question from the chat room again, how do we determine if the establishment, the restaurant they're talking about, qualifies as a bar or a restaurant? Is there a directory or something posted, inside the restaurant usually?
Not that I've seen, and that's part of the challenge. I mean, I think to some degree it's common sense. If you're going into something that is clearly a bar and they serve bar food, then you can presume that it's a bar, not a restaurant. But if you're going into some place like Chili's, where there's a large restaurant footprint and it also has a bar in it, then that's probably a restaurant, and you can safely carry.
All right, another again. If you're involved with a self-defense shooting and the police started questioning you, what should be said to the police? Should you wait for legal representation?
Absolutely. If the police are questioning you about something you did as opposed to something you saw, that means you're a suspect, not a witness. And you can never, ever help yourself by talking to the police. You can only remain neutral or hurt yourself. So it can never be used against you that you said, I want to wait till I have a lawyer present. They cannot use that against you. It cannot hurt to say, I would like to wait for a lawyer. And I would encourage anybody that's being questioned by the police about their actions to talk with counsel first.
I know we haven't talked about this yet, but we talked briefly before this meeting started about DUIs.
Sure.
So that brings to mind, if you get stopped by a policeman and they ask you, have you been drinking? How would you answer that question?
If you get stopped and the police ask you, have you been drinking? That presumably means that they smell alcohol. Well, not alcohol, because alcohol is odorless. They smell, in the police report, it says, I detected the odor of an alcoholic beverage. What they're smelling is the other
your
stuff
breath,
in the alcohol, not the alcohol itself. But if if the police are asking you, have you been drinking? They presumably already know that you have because they can smell it. And therefore, if you say no, there's another indicator that you may be impaired, because now you're not only having alcohol on your breath, but now you're not being fully honest with the police. Obviously, the best answer is just don't drink and drive. Take an Uber, take a Lyft, have a designated driver. That being said, it is not illegal to drink and drive. The challenge, though, is that if a police officer stops somebody and detects alcohol on their breath, the police officer, in my mind, they're going to make the determination that it's safer to have this person detained and arrested for DUI as opposed to take a gamble that they actually are not DUI, let them go and have them ultimately get into a car accident, and then the police officer's on the hook. Why didn't you arrest this person when you had them? So the best answer is to just politely decline, as you have a right to do, politely decline to do any answer any questions. If you do that, the police officer will, and they probably would anyway, would ask you to step out of the car and either ask you or instruct you to do what's called field sobriety exercises, which is there's a battery of standard tests, and they will put you through those tests. And at the end, they say, I'm going to do those tests to determine whether or not you can safely drive. It is my belief that if you are going through that battery of tests, the police officer has already made the decision that you're going to be arrested. And those tests are simply being recorded for the purposes of gathering evidence for the prosecutor and ultimately potentially for the jury. So that's...
All right, so another question from the Zoom room. If I'm walking, or Zoom chat group, if I'm walking down the street or riding my bike, carrying my lawfully concealed weapon, and a dog breaks loose from owner walking their dog, and the dog attacks me, can I shoot the dog? Is this would this come under stand your ground, legal stand your ground?
It very well may. It very well may. I mean, there's a couple variables. One is the person riding the bike, presumably they're in a place where they have a right to be. If you are legally in a place where you have a right to be, you do not have a duty to retreat if you are confronted with great bodily injury or death. If you are not in a place where you have a lawful right to be, then you actually do have a duty to retreat or to try to retreat until you can any longer, and then you can resort to deadly force. So the first assumption is that this bicyclist is where they have a lawful right to be. The second assumption is all dogs are not created equal. If this is a 15-pound Maltese versus a 100-pound pit bull, that certainly makes a difference. That I would say, if you have a reasonable fear that you are in jeopardy of serious bodily injury or death, you have a right to defend yourself.
Yeah. So if it's a poodle coming up, wagging their tail, acting friendly, and you just don't like dogs, just because they're in your space doesn't mean you can shoot them, basically.
Correct. It's not whether you have a subjective fear, because you may have post-traumatic stress disorder from a previous dog bite and you don't like dogs and you have a visceral reaction, but it's not a subjective standard to you. It's an objective standard to the reasonable and prudent person situated in the same circumstances. So in that situation, would a reasonable person be afraid that poodles can be mean? So I don't like the poodle example, but a golden retriever, a reasonable person would not think that a golden retriever wagging their tail would be posing a threat of death or great bodily injury.
All right, so another question from the chat room. I bought my pistol from an authorized gun dealership. I don't seem to have a registration form. I don't think I was given one with the purchase. Is there somewhere that I can look up my registration form? Does the state keep a record of all guns sold, I guess is the question, through some type of registration?
I think my recollection is that the store keeps a record of that transaction, and I'm not sure how long they have to keep it, whether it's a number of years or forever. I don't recall specifically, but I actually have personally had an issue similar to this. I had a firearm that I had for many years that I believe was stolen out of my Jeep, and it was missing. So I, of course, had to call and make a police report that this firearm was stolen, and I did not have the registration. Fortunately, on the box that the firearm came with, and this may be the same for the person that posed the question, on the box that the firearm came with is the serial number. So you would be able to give that serial number. In this case, is what I did is I gave the police the serial number on the box that the firearm came with.
Now, so do all firearms that are stolen have to be reported to the police?
I think it would make a lot of sense to do that, if only to establish that it's no longer in your possession. My concern was that if the firearm is stolen and subsequently used in a crime, and the serial number is somehow traced back to me through some FBI database or however it is done, that they would now come back to me and say, hey, you have a firearm that was used in a crime. Where were you last Tuesday? Now I'm explaining, I didn't, it was stolen. I don't have it in. But of course, I don't have a police report showing that it was reported stolen. So
now, what about if a person makes a gift of a weapon?
Well, so there's a whole
same thing,
number.
I guess.
Yeah, same thing. If you lawfully possess a firearm, now there's different rules with private transactions versus commercial transactions. But if you lawfully possess a firearm and are dispossessed of that, there should be some contemporaneous report for your own protection to say, as of this date, I no longer have it.
All right, the next question is, I guess this one's for me, Hunter. It says, if you have a trust, do you put guns in it? Now, that's a great question. There are such things as gun trust. Generally, the question could be expanded, which it's not, but I'll expand it to say if a person dies and has guns in their estate, how will they distribute it? And are there any special rules about guns in estates? Well, there's a National Firearms Act that has regulations about certain guns, like sawed-off shotguns and machine guns. If you put a silencer on a weapon, or you buy something to modify the weapon to make it more of an automatic weapon that can shoot large rounds of ammunition at once. So the National Firearms Act has certain guns, and if you have one of those in your estate, there are special rules of how that gets distributed. Also, you got to be careful, because if your estate gives a weapon to a felon who can no longer have weapons or can't have weapons, then that's a special situation too, where you have some liability as the personal representative of an estate. But guns are personal items, and they can be addressed in the will under a separate writing with personal if it's just a simple handgun or maybe a hunting rifle. You don't have to have a trust necessarily to put those in, and they're personal non-titled assets that can be, to answer the question, they can be distributed out of an estate if done properly. I usually tell my clients, if you have guns in an estate to be distributed, the best thing to do is to go make any transactions or transfers at a gun store that's licensed to deal with guns. Is my general advice on that subject. Do you have any comment about that, Hunter?
No, I defer to you in all matters of trust, but you did mention the
National Firearms Act.
When you're talking about gifting a firearm from one person to another, you have to make sure a couple things. One is that it's not a straw purchase situation. In other words, I, who can lawfully purchase a firearm, am able to do that on my own behalf. But if someone over here says, hey, I can't buy firearms because I have this or that prohibition, will you buy it for me? And I buy that firearm specifically for the purpose of turning it over and selling it or giving it to this other person, that is circumventing the prohibition on sale to unlawful people. And not only is he going to be in trouble for possessing it, but I'm going to be in trouble as a straw purchaser. So you have to be careful not to do that.
All right, Hunter and I were prepared to talk for a long time today, but we've got so many questions, Hunter. I guess we'll just continue answering. Hunter and I do radio together. It's always much more fun to talk to an audience than each other, because we can talk to each other anytime. And audience questions are great because a lot of people have these same questions. And if Hunter and I answer your question in the chat room, it probably applies to other people who are thinking about it as well. So the next question in the chat room is, can you openly carry your sidearm in a holster on your property if it is not displayed in a threatening manner?
I would generally say yes. Now, of course, there's some questions that I would need to answer, some details. When you say property, are you talking about a 10-acre farm in the middle of in a rural area, or are you talking about in a condo in a little backyard, or inside your house versus outside your house? But generally speaking, it's your property. I don't know that there's a prohibition against carrying a firearm on your own property, provided you're not doing it in a menacing way, provided you're not running afoul of some other prohibition.
So, Hunter, you own a 1/4 acre in a community where the homes are fairly close to one another. You don't like your neighbor. So can you wear your holster with your gun weapon going up on your own property, walking up and down the property line?
I mean,
just changed the question a little bit.
But it doesn't make, I mean, probably, but it doesn't mean it's a good idea.
Yeah.
Is that an arrestable offense? Probably not. If it's open carry on your own property, but like I said, it doesn't mean it's a very good idea.
Yeah, if your neighbor is playing loud music and they constantly offends you, you can't go be waving a gun at them, telling them to cut their music off. I mean, that would definitely be a crime.
Yeah.
All right, so sister moved here from Illinois where she had a concealed carry license. What does she need to do to be legal in the concealed weapons here in Florida? Can you legally carry pepper spray or tasers for personal protection? Do you need a conceal and carry to legally carry or use them? You need a permit for a taser?
Yes, you do. Those are weapons. And to carry a concealed weapon like a taser, you do need a concealed weapon, because it's not a concealed firearm license, it's a concealed weapon license. But as to the prior question about Illinois, so one thing that I never fully understand is why, and the United States legislature, is this topic always comes up, but the idea of reciprocity, national reciprocity. I have 2 licenses in my wallet. One is a driver's license. I don't have a right to drive, and yet that license is good in all 50 states. I also have a concealed weapons permit, which allows me to possess a firearm, which is a constitutional right that I have, and yet that doesn't reciprocate in all 50 states. I never understood why that's the case, but I suppose under 10th Amendment ideas in terms of every state can define their own
well
law.
But Hunter, let me say this: if you have a driver's license in Florida and you move to Illinois, you're going to have to get a driver's license in Illinois.
Yes, that's correct.
So if this question is she has a carry license in Illinois and she moves to Florida, does she have to get a new carry license in Florida?
Ultimately, she will have to. Florida has reciprocity with a number of states. And you can look it up. It's on the Department of Agriculture website. Offhand, I don't know whether Illinois and Florida have firearm reciprocity or not. But assuming that, well, if Florida and Illinois do not have reciprocity, then her Illinois carrying concealed weapon permit is ineffective in Florida. It doesn't count. If Florida and Illinois do have reciprocity, then she would be permitted to use her Illinois license in Florida for a period of time. And if she is domiciled in Florida, if she moves permanently to Florida, then presumably at some point she would have to apply for a Florida concealed weapons permit. If she is here temporarily, then she could potentially just rely on her Illinois license for the period of time that she's going to be here. But that, before I advise someone you are good or you are not good, I would want to delve into that more, just to make sure that I knew what the period of time was and whether or not there's reciprocity.
All right, please discuss, another chat room question, please discuss please discuss if trespass with a firearm can be prosecuted as a felony.
Absolutely. Trespass. So a burglary, people often get confused about what constitutes a burglary, that you have to steal something. Burglary has nothing to do with theft. Burglary is simply trespassing with the intent to commit a crime on the area that you're trespassing. And so if you enter into, for example, somebody's private residence with the intent to commit some crime, doesn't matter, it could be stealing, it could be another crime, that is a burglary. So if you are committing a burglary and you have a firearm, you are now guilty of armed burglary, which is obviously a much more serious offense. So that would be more than trespass is a misdemeanor, but armed burglary is, of course, not. So yes.
All right, so a question from the chat room again, and we'll maybe, does anyone have a live question? Just let us know there, and we could take a few live questions today too, if you would like. Troy is co-hosting the program, and he should be able to monitor any live questions that come up. We'll be glad to post those as well. So if I leave my pistols and rifles to my children and/or grandchildren in my will, is there anything special they need to do? No, the personal representative can take care of that. If I were the personal representative or advising the personal representative, I would get receipts from anyone who received the weapon, so to show it and transfer it out of the estate to someone. They're not titled assets, so make sure you're not leaving it to a felon who can't have a gun. And if you do it to grandchildren, that's a little difficult if they're not of age. Make sure everyone's of age to be able to receive a weapon. Make sure you're leaving it to people who have wisdom or would have wisdom about handling guns and the proper use of guns. And there are a lot of things involved in leaving guns in an estate, and that does put a burden on the personal representative to do all this in a proper way that wouldn't cause harm to anyone. A lot of times on guns, if families are not that interested in guns, personal representative can just sell those guns to a gun shop or privately. Just make sure the personal representative should always get receipts of where the gun went in case it becomes a question later on. So question was, it says FWC has carte blanche to search anyone, anytime for no reason. Is that a true statement, Hunter?
No, under certain circumstances that might be true, but if you're driving down the road in your car, an FWC officer can't just pull you over randomly. If you are on a state park, then the rules might be a little bit different, but or if you're on the water, I think that's probably what they're thinking of, is if you are on the water, an FWC officer can search your boat at any time without any reason. But that gets back to no Fourth Amendment on the water, like we discussed before.
What's the law for someone to be practice shooting? We live in a subdivision and hear a lot of gunfire in the area. Do shooters have to be a certain number of miles away from a subdivision or another home?
Well, I don't know. I saw that question before. I don't know the circumstances of that shooting. I know there are a number of outdoor ranges where people can go to target shoot, and that may be what's happening. I know I go to a park, a state park all the time, where I often hear firearms, and I inquired why, and that was because there was a sheriff's office training facility adjacent to that park. So it may be something like that, but generally speaking, you cannot just set up a target area in your backyard in a subdivision and start popping off firearms. That is not legal.
Here's a question. If an intruder is in your home and turns to run when they see your gun, you're in the process of firing and hit them in the back, what is the consequence?
Well, again, it depends on a number of details that weren't provided, but the gets back to the stand your ground. Would a reasonable person in that situation feel that they were in jeopardy of death or great bodily injury? The question is the person running away armed or unarmed? Are they on your property, or by the time you shoot them, have they left your property? If you have shot someone in the back that is not armed, that is not a situation I would want to find myself in. If they're running away, presumably the threat has extinguished and you are no longer in fear of death or great bodily injury. That being said, if as they're shooting, they're firing behind them, then you still are in reasonable fear of death or great bodily injury, and then you would be entitled and justified in shooting.
What do you do if they're running out with a very expensive item from your home they've just stolen?
You cannot use you cannot use deadly force to protect property. You can use non-deadly force, but you cannot shoot someone because they're stealing something of value to you.
All right. Well, this is people used to joke about this. I know it's not a funny subject. If you shoot them and they're outside your house, you drag them back inside. So
that was what my torts professor said. He said, that was before stand your ground, but he said, if somebody's in your house, shoot them. Somebody's about to be in your house, shoot them and drag them in your house. But don't do that.
That's not legal advice, though. We're
don't
just
do that.
All right. Let's see if they can trace. Let's see. So featuring Christine's question, if you shoot an intruder after they've left your home but were on your property, what is your liability? I think we probably addressed that.
Yeah. Again, I mean, the further you get away from being directly confronted with force, the more likely you are to find yourself in legal jeopardy.
What do you do when you travel interstate with your Florida concealed weapon?
First thing you do is check the reciprocity list on the Department of Agriculture website and find out whether the states through which you are going to be traveling have reciprocity with Florida. But that's for carrying a concealed weapon on your person. In Florida, you do not need a concealed weapons permit to have a firearm in your vehicle, provided that it's not on your person. There was an interesting case that came up with the guy that had a firearm without a concealed weapons permit in a fanny pouch on a motorcycle. What was the issue? Whether that was carrying a concealed firearm, or was that carrying it in a conveyance? But so you do not need a concealed weapons permit to have a firearm in your vehicle, provided that you can lawfully possess a firearm. You're not under a domestic violence injunction. You're not a convicted felon. You're not any number of the other exceptions.
So traveling state to state is no problem having guns in your suitcase that are in the trunk. You're just carrying them in your suitcase. There's nothing wrong with that.
It depends on the state. In Florida, that wouldn't be an issue. In California, it would be a different issue than it is in Florida. So before you do anything like that, it's important to know what the laws of that particular state are. I recall a gentleman that got into very serious legal jeopardy in New Jersey. He was a member of the military, and he was moving from his parents to his own house, and he got stopped with firearms in the trunk of his car in New Jersey, and he was in very serious trouble.
Yeah. Is it legal to carry pepper spray?
Depends on the kind of pepper spray. Generally speaking, I believe you can carry pepper spray, for example, in a purse or on your person, because that's not generally considered a weapon. But there are gradations of pepper spray as well. Mace, for example, I think that is considered a weapon. For that, you need a permit for, which is generally speaking, I don't think you need a permit for mace.
Here's a great question. I think that would a lot of people might be concerned about. If my son is convicted of a felony, can he live in my home, which contains personal firearms?
This comes up a lot. I handle situations like this. The short answer is yes, he can. There are, of course, lawyers make everything complicated. So there's different kinds of possession. There's actual possession, which is I am actually possessing this pen. But if I put that pen down next to me and I'm in a room alone, I have constructive possession of that pen. So it is illegal for a person with a felony conviction to actually or constructively possess a firearm. So what I advise people to do in that situation is to have those firearms in a room, their own bedroom, as opposed to the felon's bedroom, in a safe where the firearm owner has the combination to the safe. Because envision the scenario where the police come into that house for whatever reason, presumably lawfully, otherwise it's subject to a suppression motion, but come in and see firearms. The more evidence they can collect tying the felon to that firearm, the more likely they are to charge possession of a firearm by a convicted felon. So where that comes up, for example, is in a bedroom with the husband and wife where the husband's a felon and the wife is not. I've had that scenario. And they say that they find the firearm next to somebody's wallet in a dresser drawer with nothing but men's boxer shorts and no ladies' clothes. So they can make a pretty good case that that was constructive possession. But again, they have to prove constructive possession. And if there's joint ownership of that room, if there's non-exclusive access, then it makes it harder to establish a case of constructive possession.
All right, we got an expungement sealing question, Hunter. We were going to talk about that, just never got around to it, but here's a question for you. So 18-year-old male, misdemeanor, high school, throwing eggs on property. Should he have his crime expunged? Fred Fowl might refer to him as a pedophile, hiding something better to leave. That's how it's posed. So
that's a couple questions. First of all, generally speaking, the law there's two different procedures: sealing, which is different than expunging. And without getting too into the legal weeds, sealing is essentially they hide it from public view, but the case still exists, the file still exists. And expunging is they get rid of the file altogether. If you go through a diversion program or the case is dismissed, then you would be eligible to have the case expunged outright. And in fact, a year ago, they changed the sealing and expunging statute to now the new statute that they passed has a provision for automatic expunging of certain cases where if the charges are dropped or you go to trial and are found not guilty, there will automatically be an expungement of that case. But there's something in Florida called a withhold, which without getting too complicated, a withhold is you're guilty, you're just not convicted. If you plea and receive a withhold, you would be eligible to seal that offense. And once it's sealed, you wait a number of years and then you can ultimately expunge it. There are certain offenses that do not qualify for sealing or expunging. Child victim crimes, for example, certain drug trafficking crimes, things of that nature. But if it is not an enumerated offense that doesn't qualify, then you can seal and ultimately expunge. Now, here's the rub. You can only do it one time in your life. You can only seal or expunge one case. And if you ever get a conviction, you forfeit the right to seal not only the case that you were convicted of, but any case that you've ever had. So if you have a withhold on your record and you are eligible to seal that, but 10 years from now get a conviction on a criminal offense, you lose the right to seal both the criminal conviction and the withhold. So, like I said, you only get one bite at that apple. So the question is, do you want to, well, the first question is it going to be automatically sealed? Were the charges dropped, or did you get a pretrial diversion program? If they're not going to be automatically dropped, do you want to use your one bite at the apple to seal this case, knowing that you can only do that once?
I'm going to summarize one more question. We're going to do one more question. There are other questions that we're probably not going to get to today. But Hunter, why don't you give, before I take this last question, why don't you give all of your contact information if they want to contact you privately?
Sure. My office phone number is 813-444-4777. 4 4s and 3 7s.
All right, go ahead and give it one more time.
Sure. 813-444-4777.
I'm going to summarize this last question somewhat. So if you're on a boat, can FWC impound the weapon you have on your boat if you don't have a concealed weapons permit?
Well, if you're carrying, generally speaking, no. In order to, was it forfeit the gun or the fire or the boat?
Well, it was a two-part question, but this was on a boat. The firearm was on a boat. He did not have a concealed weapons permit. FWC finds a weapon on his boat. Can they impound it?
Impound the weapon. If you are committing an offense, in other words, you have the firearm is concealed on you, you are committing the offense of carrying a concealed firearm without a permit. That's a crime. FWC can take the firearm into evidence, and as part of a plea, you may have to agree to forfeit that weapon. If the firearm is not being carried in a concealed manner and you otherwise can lawfully possess a firearm, then you are not committing an offense, and there'd be no reason that they would be permitted to take that firearm because it's not being used or is part of a crime.
All right, if you have no concealed weapon permit and you're in the middle of a full-scale riot, what are your rights of self-defense?
Sadly, that is not necessarily entirely unrealistic or hypothetical these days. So if you have a concealed weapons permit and you're in the midst of a full-scale riot, well, I'll answer this question. Now, there have been a number of notable examples in the news. In Florida, again, assuming this is in Florida, and you are lawfully where you have a right to be, in other words, you're not on the street after the police have declared a riot and imposed a curfew. If you are lawfully allowed to be where you are and you are confronted with death or great bodily injury, you are confronted with deadly force. Under the stand your ground law, you do not have a duty to try and retreat. You can defend yourself from deadly force with deadly force. If you are not where you are lawfully supposed to be, in other words, the police have declared a riot, the police have imposed a curfew, the police have lawfully told you to leave the area and you have not, you are now not lawfully where you are allowed to be. Therefore, you don't have the benefit of the stand your ground. You have a duty to try to retreat before you resort to deadly violence.
All right, one last question. I want to add one more because it's just kind of an interesting question. Then we're going to cut this off right after this, Hunter. What is the law about having a BB gun?
BB guns are not firearms, but they are weapons. So I'm not sure, that's a fairly general question, but the question is, for example, can you carry a concealed BB gun? And I would say no, because BB guns are in fact weapons. And there is a different statutory crime carrying a concealed weapon versus carrying a concealed firearm. You can be prosecuted for carrying a concealed weapon that is not a firearm. So hopefully that answers that question.
But shooting a BB gun on your own backyard probably is not a violation of anything.
No, I wouldn't think it would be, assuming again that you're not firing it at someone, or it probably is not criminally liable but there may be civil liability if the BB gun leaves your property and hits someone.
Okay, I'd like to thank the audience for attending today. Thank you, Hunter. I wanted you to know that I have a radio show, Ask an Attorney, all about Florida law. It's been gone. We started our 37th year. Hunter's been on a lot of those shows in the past. If you'd like to listen to the radio show, it's on Saturday mornings at 8 o'clock. The local stations in the Tampa area are 570, 910, 860, 930. There's a community station in Sun City Center that carries the program 96.3 FM and 100.1 FM. It's also heard in Haines City on 90.3 FM. In Jacksonville, might have some Jacksonville people today from the audience on 600 AM. The Answer on Sunday morning, I'm doing 970 radio from 3 hours to 6 to 9 o'clock. It's a live show where you can ask questions just like you did today from the chat room. Thank you so much for attending. If you attended and you got this from an email from me, you're on the email list and you'll be sent all future invites to future meetings. If you did not contact us directly by email, give us your email address and we'll add you to our list. Hunter, go ahead and give your phone number one more time and say goodbye to everyone.
I will. I put my email address and my phone number in the chat box. So if you see that, copy, paste it, and keep it. My phone number is 813-444-4777. And my email is just hunter@chamberlinlawfirm.com.
Hope everyone has a great weekend and be safe. And we'll see you next time. So long.
Thank you very much, Joe.
Thank you.